Good afternoon and welcome to part 5 of Schoeneck King's webinar series on data privacy and cybersecurity for higher education institutions. This webinar series focuses on the intersection of higher education and data privacy and cybersecurity. Today's discussion will focus on cybersecurity and data privacy considerations in the admissions and marketing realm. If you have questions during this discussion, please use the Q&A box located at the bottom of your screen, and we will do our best to answer questions as time allows. Please remember to fill out the questionnaire following the presentation. Today, we are pleased to welcome Jane Sovereign to our series. Jane is a member of Bond's Higher Education Practice Group and has been counseling higher education institutions for over 30 years as both in-house and external counsel. Before joining Bond, she served as Deputy General Counsel, Interim General Counsel, and Vice Chancellor for Legal Affairs at the City University of New York. Her practice focuses exclusively on representing colleges and universities in all aspects of higher education law. Specific to our topic today, Jane represents institutions in negotiating a wide variety of academic issues, including accreditation, governance, Title IX issues, and internal and external investigations. Thank you so much for being here today, Jane. We also welcome back Shannon Knapp, who is joining the series for the third time. Shannon is an associate in our cybersecurity and data privacy practice group. She is a certified privacy professional through the International Association of Privacy Professionals with a particular focus on U.S. privacy law. Shannon advises clients, including institutions of higher education, on a wide array of data privacy and cybersecurity issues, and she has particular proficiency in data privacy laws focusing on marketing via telemarketing, text messaging, and emailing. Thank you for being here again, Shannon. Finally, I'm pleased to be presenting alongside my colleagues today. My name is Amber Lawyer, and I'm Deputy Chair of Bond's Data Privacy and Cybersecurity Practice Group. I maintain 2 privacy professional certifications in U.S. and European privacy law, and I assist higher education institutions with general privacy law compliance, technology transactions, and data governance. Thank you all for joining us today. Let's get started. Jane?
Sure. Can we go on to the next slide, Kathy? Thank you. Quick overview of what we're going to be talking about. First, the applicable law with respect to, in particular, marketing and admissions issues, vendor management, record-keeping requirements and best practices, the TCPA, the Telephone Consumer Protections Act, and alumni donations, and then everyone's favorite name of a higher education law and relating to all of us, CAN-SPAM, which I'll remind you all is the Controlling Assault of Non-Solicited Pornography and Marketing Act of 2003. We will talk about data privacy and security, in particular in marketing and admissions, and close with emerging issues. Next slide, please, Kathy. There are a host of different information and data that you all get from prospective students and alumni through all kinds of ways: application materials, medical attestations, financial aid forms, payment processing via credit card, alumni database, websites, donations, and fundraising campaigns. Every one of these gathers on a routine basis very sensitive information from folks, prospective students, admits, and alumni. So there's a big universe here of this kind of information. Kathy, next slide, please. These are some of the applicable laws that we are going to be talking about. of course, everyone's standby, FERPA, Title IV, and the GLBA safeguards rule, the two most important international privacy laws, the GDPR, PIPL, this TCPA, the Telemarketer Act, CAN-SPAM, and data breach laws and regulations, of which there are state laws and many issues there. So Amber, I'm going to pass it on to you, and Kathy, can you put it to the next slide?
Thank you, Jane. So we wanted to start with vendor management in relation to marketing and admissions and kind of tie in some of those applicable laws. What's really important to note in the admissioning and marketing space for higher ed institutions is that you outsource a lot of your technology in relation to in order to perform your duties in admissions and marketing, right? So we need to contact prospective students. We need to process the personal information of students as they enroll. We need to then leverage the information that we collect for marketing. And how we do that is often by bringing in third-party providers to process that information, to utilize it, and then leverage it. And because we're doing that, these third-party vendors often have information that is regulated pursuant to applicable law. So if we think about information of foreign students, we may be concerned with the GDPR, the General Data Protection Regulation. We may also be concerned with students that are coming from China and the personal information regulation there. And because of that, we need to ensure that we're adequately vetting our vendors, making sure that they're going to protect the information of your students, of your alumni, even of your employees, and that they're going to process that information in a way that doesn't violate applicable law and doesn't put your institution at risk. And so we've cited a few of the marketing vendors that you might be using. What you want to do is make sure that you're vetting those vendors throughout all phases of what I call of a contract, the pre-contractual phase all the way through the enforcement and oversight. And so when you're looking to take on a new vendor, maybe a Salesforce or a Workday, and they're going to assist in the storage, hosting, and processing of your information, you want to make sure you're doing a review of the agreement before they touch any of your data. And it's really essential that you vet them to make sure that whatever applicable law may come into play in relation to the data that you have, you're incorporating that into the contracts. Next slide, Kathy. And so here are the phases that I was talking about. And we actually have a pretty detailed webinar that goes into each one of these phases and what you want to look for in terms of a marketing vendor or an admissions vendor and some of this tech that we're talking about. But I just want to talk about it in the admissions perspective, right? Or the marketing perspective. So if you want to take on a new marketing or admissions vendor, we need to do a couple of things. We need to determine what data that vendor may have, and we would do that in the pre-contractual phase. So are they going to have access to the institution's network, to all of your admissions information? What level of information is that? Is it sensitive information in relation to the student? And we want to do that in the pre-contractual phase. We want to do adequate diligence in relation to the vendor and what security precautions they may have. You may handle all of this in an RFP, right? A request for proposal. So we might ask them those questions and ask if they maintain cybersecurity insurance, all in this pre-contractual phase. Then when you get into the contract review, we would want to take those applicable laws, so FERPA, GDPR, and we would want to ensure that we have adequate coverage within the contract. So just another check to make sure that you have the required contractual provisions in relation to those laws. The new GLBA safeguards rule mandates that you have certain contractual provisions in relation to the security precautions that your vendors have. So you would want to incorporate those into the contract. And then what's really important is that you have some sort of oversight after execution, right? So that we don't just sign this and forget that our vendors have to maintain adequate precautions. So you want to make sure that you're still reviewing your vendors and making sure they're meeting their technical safeguards to your satisfaction over the course of the term of the contract. Next slide, please. Jane, I'll turn it over to you.
Sure. So record keeping is one of those issues that we can't emphasize enough for all of you. We're talking about a whole lot of ways to protect sensitive data, to avoid breaches and avoid all the things that come from them. And one of the very most important ways is by not keeping any data that has sensitive information longer than you need to. And this is certainly true in admissions, in particular. We've talked about this before, but important to remind ourselves, it's critical to have a records retention schedule and policy and to follow it. If you have sensitive information that you're supposed to keep for, say, 2 years, and you have a data breach and there's information from 25 years, the breadth of what you are going to have to clean up is so much bigger than it needed to be. So that's a plug and really important. The guidance in terms of admissions record keeping, the FSA, the Education Department, has in their FSA handbook covering students who are getting federal financial aid. Their guidance is that essentially you need to keep admissions data for 3 years. And that means financial aid data, admissions data, and so forth. The trick to this, which makes it not so simple, is that specific data has the 3-year period begins to run in different places. So this is something you'll need to watch carefully. Next slide, please. And we did a little bit of looking in New York State at colleges and universities that have records retention policies to get a sense of what were the common practices for retaining admissions records. And what we found is right here. If the applicant doesn't attend, most institutions that we looked at, both public and private, keep that data for 2 years. For applicants who do enroll and become students, that admissions information, the private schools generally keep on a 5-year basis, publics generally on a 6-year basis. And of course, public institutions in New York have some statutory and regulatory obligations with respect to retention of thing. So these are some common practices that can be helpful for you. I would note again that one thing Bond does is assist clients with creating and setting up a records retention policy and schedule. So that's something you can ask any of us about if you need assistance on. Next slide, please.
Okay, so one of the ways that marketing and admissions has become regulated recently is that in the form of disclosures and providing adequate notice. So of course, we've always had FERPA notice, but What we're seeing now in terms of GDPR and PIPL and some of these new privacy laws is that you have to be providing adequate disclosures in your marketing materials, on your website, and it's kind of a sea change, a little bit of a shift from what we used to have, which was just collect everything in every manner through every platform and just tell the consumer in a very short privacy policy that we may be collecting it. That's not necessarily best practice anymore. What we're seeing is that you need to have detailed privacy policies and disclosures at the point of collection. And so it's really important to be updating your website privacy policy to ensure that you're providing disclosure, you're telling prospective students, alumni, folks that may be hitting your website, just end users, what you're collecting from them, why you're collecting it, via what means you're collecting it. So is it through cookies? Are you doing any other kind of technology that collects information via pixels or something like that? And what you're doing with the information if you're sharing it with third parties. So really important to have updated privacy policies, to monitor your website interaction. So if you're using any of that tech, including third-party providers, that you understand what you're doing via the platforms that your prospective students, data subjects are interacting with. If you need to obtain consent, you need to do it in a way that is informative to the data subject and really gives them a fair choice in relation to that consent. If you're doing telemarketing or text messaging or emailing in any kind of donation solicitation, any kind of campaign, you need to make sure you have adequate disclosures and notices, and sometimes the ability to opt out. And Shannon's going to get into all of that right now. Next slide, please.
All right, so we're going to hop over to the Telephone Consumer Protection Act. This law has been around for a while, but as technology has advanced, the scope of this law has increased substantially since it was first passed in the early 90s. And it definitely applies to both the marketing and mission side of things, as text messaging is one of the fastest and easiest ways to communicate with people, as well as phone calls. And so this law is directly applicable to a lot of the practices that both marketing and admissions are handling. So there is a private right of action, meaning that individuals can sue for violations of the law. And the violation penalties are pretty steep. It's up to $500 per violation. So for example, for every text or phone call that you make that is in violation of TCPA, that's a $500 violation. And if a court finds that you're willfully or knowingly violating the law, it's up to $1,500 per violation. So as you can expect, if you're sending out mass marketing emails and every single one violates, you could have a very steep penalty very quickly, which is one of the big reasons why TCPA compliance is so important. And it was actually back in the 90s, the law was passed in the wake of a denial of service attack at Emory University in 1990 that involved 10,000 phone extensions receiving recorded calls, and there was no way to disconnect it. And Congress passed this law as a result of that. And NACUA and the United Educators interpret TCPA as covering private non-for-profit colleges. And so there is no exemption, unlike other privacy laws, for higher education institutions. So this is something that does need to be paid attention to. You can go to the next slide. So one of the biggest parts of TCPA is consent. It's very much a consent-driven law. And the FCC on a 2016 declaratory ruling for Blackboard really clarified some of the applicability to education institutions specifically. And basically what the 2016 decision found was it permits colleges to send robocalls or automated texts under two circumstances. And I also do want to clarify, I haven't said this yet. So TCPA generally only applies when you're using an automated dialing system, meaning that you're using some sort of robocall or automated text messaging system. It doesn't apply if you have someone sit down and individually send a text message to an individual. Although we usually suggest that for any sort of communications you're doing, that you still follow the TCPA, but that's just something to note. But in this decision, they found that there is permission in two circumstances. One is with prior express consent. And so if you receive prior express consent to contact them at their phone number, you can send non-emergency closely related to the school's missions information calls or text messages, things like upcoming parent-teacher conferences or things about general school activities. If there's like a canceled class, things like that. And the definition of consent in this circumstance is if the student provides their phone number to the education institution, then it's considered consent unless they indicate to the contrary. And then you also can contact without consent, and this is really only for emergency purposes, such as weather closures, fire, health risks, threats, unexcused absences, things like that. So you don't need consent at all if you are sending for emergency purposes. But there are some details about what's considered emergency purposes, specifically under the Clery Act, which if you want to learn more about, please let us know. Next slide, please. And so marketing, which is one of the bigger parts of when you're going to be sending text messages, it was made pretty clear in the FCC Blackboard case that reports of schools using platforms to call about ballot issues or marketing of any kind does raise TCPA concerns. And the Franklin D. DePaul University case was a similar case concerning this, where DePaul University was sending a number of text messages to a student who tried to opt out, although possibly incorrectly, and then sued for TCPA violations. And as we said, TCPA is very much a consent-driven law. And although the consent doesn't necessarily need to be written for nonprofit institutions, we do suggest sometimes that you do obtain written consent so that you have a record of it in case you do fall into the situation where you're facing a lawsuit or a complaint. And the unwritten consent requirement does apply to your vendors as well. So if you're using vendors, then they follow the same guidelines that you do, even though they might be a for-profit entity. And FERPA, there is crossover between FERPA and TCPA. As soon as phone number is generally considered directory information, but you might want to check your own FERPA policy to make sure that is how your school characterizes it as well. Next slide. And so concerning alumni, it gets a little bit more complicated because if someone as a student indicated that they did not want to be receiving messages, there's a question of whether that opt-out needs to be respected if they are as alumni as well. The CFR does seem to make clear that you have to continue to honor a valid opt-out request of directory information sharing. So for example, if you were sending text messages to the student and then you share with your alumni relations, if they did opt out of disclosure of directory information, then that opt-out needs to continue to be honored and then not shared. However, for TCPA concerns, the opt-out might be a little bit different and might need to be looked at on more of an individual basis, depending on the practices in your TCPA policy. Amber and Jane, do you have anything else to add?
No, I think you covered it well. Thanks, Shannon.
All right. Sounds good. Oh, you can go to the next slide. So can spam, moving more to email marketing instead of phone and text messaging, as Jane indicated, it's the Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003. And unlike what a lot of people think, can spam doesn't prevent you from sending unsolicited messages. You can do that. You just have to follow certain outlined statutory requirements in order to do that. And there is penalties for violations, specifically if you don't honor opt-out requests. That's probably one of the biggest focuses of the Can Spam Act. So if you are sending email marketing, you can't have a false or misleading header, and you can't have a deceptive subject line. So basically they don't want you to put in the subject line something that's like a clickbait so that people click on it. They want you to be honest and not deceptive in what the email is, and make clear that it is a marketing email. And then if you do actually receive prior opt-in to send emails to students or to those you're marketing to, you don't actually have to make clear it's an advertisement, but you do still have to follow the rest of the CAN-SPAM requirements, including the opt-out methods. And as I said, one of the biggest requirements under CAN-SPAM is the right to opt out. So even though it's not an opt-in requirement, you do have to provide an easy to use opt-out method. As many of us have seen from the many emails that we get, most people just on the bottom of the email put an unsubscribe link that an individual can click on and easily opt out of. And you usually have to honor that request within 10 days, or else it is considered a CAN-SPAM violation. And you also, if for some reason sending things that are sexually oriented in nature, have to provide warning labels for those types of messages as well.
And the one thing I'll add here, Shannon, just a bit of crossover in relation to higher ed and admissions is once we start talking about those international data privacy laws, they're more restrictive than CAN-SPAM. So there are certain international privacy laws that require opt-in consent for unsolicited mailing. So when we start talking about unsolicited marketing materials, you want to double check that you're not only complying with US law, but if we're talking about a transatlantic or an international focus here in relation to your marketing materials, you want to double check that you're not violating any foreign privacy law in relation to email marketing.
That's also true for TCPA as well, which is a good point for any sort of just communication in general.
Yep. Okay.
All right.
Next slide.
Okay, so there are a lot of bad things and negative consequences that can come from unauthorized access to or exposure of student or alumni information. And just to go through very quickly, there are lawsuits that you can get. There are common law negligence claims that individuals, even if there's no law in your state for a private right of action on data breaches, people can still file lawsuits. In New York, we are anticipating that there will likely be a New York Privacy Act adopted in the near future, given that there is no US national data privacy law still at this time. But we anticipate that will have a private right of action. And for those of you in other states, you'll need to look at your state law to see whether there's a private right of action of individuals, which means that you could certainly get lawsuits under those laws if there's a breach. The regulatory actions here in New York, we have the New York Shield Act, and the New York AG can, the Attorney General has enforcement power with respect to that and can impose fines on colleges and universities that don't live up to the New York Shield Act. And that may include, and probably the most frequent reason for imposing fines is the failure to properly notify individuals, students, employees, alumni, other folks that their information has been compromised. And depending on, for our students, and now I guess in some cases, employees with remote work being more widespread than it was prior to 2020, other state attorneys general may be able to impose fines on your institution if those individuals in those states are not properly notified, or if you don't abide by the New York Shield Act. And again, for those of you in other states, be aware of your state law, if there is one, about data privacy and what you need to do with respect to notification. In addition to legal trouble, there's no doubt that these incidents cause business interruption and other expenses. We've seen with these various data breaches and other actions that bad actors take, whether it's ransom, or other things, that the response efforts can require your inside or outside IT folks to do a huge amount of work, but also you may need to be offline for days or even weeks. And I think most of us have seen in the Chronicle of Higher Education and Inside Higher Ed that there's a regular drumbeat of these incidents. Sometimes it's even hard to determine if there has been a bad actor. And there have been some of those complicated ones where folks have had to kind of walk back what they've told people, or not sure about exactly what happened. But it can really do a number. And now, of course, with remote work and with students online, that it's devastating if you've got a week or weeks where there's no access. Really complicates things. And of course, not just your IT employees, but all of your employees may have to devote extensive time to accounting for lost data and responding to inquiries that are going to pour in when you have something like this. And maybe even the most important of all of these is the reputational damage that these incidents cause, particularly if you don't have your act together to be able to respond quickly, clearly, and in a coordinated way that doesn't start to say things that you don't know for sure that you then have to walk back. So really being prepared to have on what you need to do by way of response, who's responsible for that. And that's really important. And your relationships that you work so hard to build with prospective students, with current students, with admits, with alumni, with donors, with the community even, that you can really do harm to those relationships, or it's not you doing the harm, but these incidents can do harm unless you have a really good and well thought out response effort and and responsive notifications. Also, if you are seeing at your institution that these issues are popping up and there appear to be bad actors getting in with some frequency or in the same kinds of ways, that's a warning signal. And that is a red flag that you should pay serious attention to, because it shows that your institution, there's something here that's not fixed, that you haven't really identified and worked to mitigate all the risks probably as well as you should. And so that's something to take very seriously. And we would encourage you to retain a very, an experienced IT consultant, or consult some of the folks like Amber and Shannon and others in Bond's cybersecurity and data privacy practice. You really need some experts to help you take a look at your what kind of risk mitigation practices and policies you have in place and what could be improved. Amber, any additional thoughts on these issues?
Yeah, sure. To put a little bit of a bow on this, one of the ways you can mitigate this risk is by doing third-party vendor risk assessment and contract negotiation, right? Because what we've seen in the admissions and marketing space is oftentimes your incidents, if you do have a data breach, can be caused by your vendors. your vendors have a data breach, and then you're responsible for that data breach. So you're legally responsible for your vendor's data breach, and you have to report in relation to your vendor's breach to the applicable state. If it's extraterritorial in scope, you may have to report to foreign entities. And so all of these risks that Jane was just talking about really tie back to mitigating before it happens in relation to vendor contract review, ensuring you have adequate policies and procedures in place in relation to a data breach, and you know how to report, and you have the IT infrastructure in place to respond, so that not only if an incident happens in your internal network, but also via your vendors, you're prepared and ready to respond rapidly and to remediate if you need to. So one important note there. And then a second important note, kind of to tie back to the privacy policies, and I'm going to kick it to Shannon here, even though she doesn't know I was going to do this, is that we have seen an uptick in students bringing actions against their institutions, arguing that there was a violation of a privacy policy, so that you've lost their information through some kind of data breach, and that they're bringing claims arguing that if there was negligence and that you violated your privacy policy. And so once again, it's another touch point to remember that you really need to make sure that those policies are reviewed and that they're adequate in relation to disclosure. Shannon, do you have anything to add in relation to that?
Not really, just that people are getting more and more creative in lawsuits, since most of these laws don't have private right of actions. Jane touched on this earlier with like common law claims and things like that. So in terms of privacy policy specifically, we're seeing an uptick in implied contract breach of contract, or even an express breach of contract claim. And a lot of these cases are still early on in litigation, but we have seen some of them surviving early, like summary judgment motions or motions to dismiss. So there is potential that this can be a contract issue moving forward, specifically concerning privacy policies. But a lot of these other claims as well, people are creative and will find ways to sue if they want to. And so just because there's no private right of action doesn't mean you're off the hook necessarily from lawsuits.
Right. Great. Anything else there, Jane?
I think we've covered a lot on this slide. So we'll take the next slide, please, Kathy.
Great. So I'll take this one. We wanted to talk through a couple of examples of phishing and smishing attacks and what we're seeing kind of in the higher ed space. So it's really important to note that emails coming in are often designed to trigger phishing attacks or the installation of malware, and simple phishing email tricks often require login of credentials or disclosure of financial information. And so what does all of this mean? Your employees and training your employees to recognize attacks, including phishing attacks, is really one of the best ways to mitigate this risk. So especially in the admissions realm, where the amount of data you hold is so essential, you want to make sure that your employees are trained, that they're never providing login credentials or any other kind of information to third parties, and that they're recognizing and reporting phishing attacks immediately, understanding that there is an urgency in the event of any attack in your internal systems. Shannon, anything to add here?
I don't think so. I think the big point that you made is because admissions and marketing both have such a large volume of information and such sensitive information, being extra diligent if you are an employee in this space is particularly important, because if something does happen, it could be a little bit more catastrophic than maybe in another area. And so diligence is definitely important, especially because most data breaches still occur due to human error and phishing and things like that.
Yeah, great point. Next slide, please. So here are two examples of phishing attack campaigns that we found And it's really, I will say, where we see quite a few incidents in the higher ed realm is in relation to your marketing pages, your admissions pages, or your donation solicitation pages, right? Where folks are asking you to sign in, provide your username, password information, or sometimes they're flooding the system with a bot in relation to your donation page. And so these are two great examples of phishing scams that look legitimate, but are not. And you just want to be wary and very aware in this space that your login credentials are probably more important than others. And so you want to make sure that you're extremely diligent in this space. Okay, next slide, please. Jane?
Yeah, so a couple of examples in the pictures, I think, are so effective to show you how deceptive these are. And it's important to realize that common phishing techniques, of course, hit on issues that are, or use words that evoke a response in the person who they're trying to get into their data. So for students, you know, things that talk about a FAFSA and Action Now and scholarship awards, or, you know, those kinds of things that just will grab and make nervous an already nervous high school student who's applying for admission and is grappling with the FAFSA and financial aid. So those are kind of, you know, little shots of whatever, adrenaline, dopamine, something when you see those words. And other common techniques that we've seen in higher education: alumni donation requests, fraudulent job postings, and then what we saw in those pictures, student and faculty account password update prompts. You're going to be locked out, you know, so it's just kind of, these happen over and over again. And that's what Amber was talking about with training. It's tough with students, but you can try. That's a tough one. But certainly for employees, you should be able to really do training so that people take a beat and think before they have that adrenaline reaction and start entering stuff into these. So very common, and higher ed is getting hit quite a bit. Next slide, please. FERPA, sort of back to the old favorite. In terms of admissions breaches, a question about sort of whose records are covered by FERPA. And of course, students, we know that, but who's a student? And the answer is, so one of the questions is an alum a student for purpose of FERPA? And the answer is yes. So FERPA does cover alumni records. The applicants, as we talked about before, are not students really, unless and until they're admitted and attend an institution. So if someone applies and either isn't admitted or is admitted but declines to attend your institution, those application records are not covered by FERPA. So sort of on both ends, a little bit different. Next slide, please.
Okay, we wanted to talk about just a couple of emerging issues that we're seeing, right? Artificial intelligence and biometric information are becoming highly regulated, right? We need to worry about ChatGPT. I'm sure you've all heard of it by now. And the ability for artificial intelligence to infiltrate higher ed, and how do we deal with it in the admissions space. So it's something to keep an eye on. We'll continue to report on it as well. And then TikTok in higher education institutions has also become an issue that coincides with data privacy and cybersecurity. And so you'll want to keep your eyes and ears out for that as well. We know that some institutions are trying to ban TikTok. Unfortunately, the student just goes off network and then may still use it. And so policies are difficult around TikTok, but it's something to be concerned about. And then one final note here that we didn't include, but I want to highlight, is that there is pending federal legislation that has stalled in relation to a national privacy law, and it currently does not exempt nonprofit institutions. And so higher ed institutions, if that legislation is to pass, will be pulled into a federal data privacy law. So just something to keep an eye on as we move forward. Next slide, please. And a couple of final key takeaways. Your employees are your first line of defense. You want to make sure that you're mitigating risk via your employees, you're vetting your sub-processors, your vendors, and you're performing adequate due diligence. You're maintaining record retention schedules and then following them. You're deleting information as soon as you can to mitigate risk. And that you have proper consents and disclosures in relation to marketing campaigns, text messaging campaigns, and privacy policies. Jane, I'll turn it over to you.
Okay, next slide, please. I think we are at the end here. We wanted to let you know there's one more webinar in this series, which is particularly timely. It's on cybersecurity insurance. And I know that many of you are undergoing renewals right now of your insurance policies or applications for new ones. This will be on May 11th, and our very learned and very expert colleagues, Gail Norris and Gabe Oberfield, are going to be discussing cybersecurity insurance, which is such an important topic, and I think that we'll learn a lot from them. There, in addition, the materials from the earlier webinars in this series are available on Bond's website, and this one will be added to that and will be posted tomorrow. So we will send a link to those materials to you so you can see them either again, or if you missed the previous webinars, to be able to look at those. We also want to say thank you very much for joining us. We really appreciate it. And we hope it's been useful, and please feel free to reach out to Shannon, to Amber, to me, or any other Bond attorney. If you're a client, if you've worked with someone else, please feel free to reach out on issues and questions that you may have on these issues. So thank you again, and we look forward to seeing you at the May 11th webinar coming out. Thanks. Good afternoon.